Welcome to this FedSoc Forum webinar call. Today, May 22nd, 2025, we're delighted to host a Courthouse Steps decision program on Barnes versus Felix, which was decided last week by the court. My name is Kayla Kleist, and I'm the Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, I will keep my introduction of our guest today brief. Certainly more brief than his career would deserve, so I highly recommend, if you're interested, you check out his impressive full bio at fedsoc.org. Today, we are fortunate to have with us Mark Levin, who is the Chief Policy Counsel for the Council on Criminal Justice and a Senior Advisor for Right on Crime, a Texas Public Policy Foundation project in partnership with the Prison Fellowship and American Conservative Union Foundation. Mr. Levin has published dozens of policy papers on topics such as sentencing, probation, parole, reentry, and overcriminalization, and his articles on law and public policy have been featured in publications such as the Wall Street Journal, USA Today, National Law Journal, and many others. And I'll leave it there. A last note throughout the program, if you have any questions, please do submit those via the question and answer feature so they'll be accessible when we get to that extended portion of today's webinar. We'll start with a set of opening remarks and then we'll be able to move into those. So if you have them, feel free to send them on through. I'll ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. Now with that, thank you all for joining us today. Mr. Levin, the floor is yours.
Yes, well, thank you so much. And it's really great to be able to do this program on such a momentous case and one that came from Houston, where I'm based. I'm not on the Sam Houston Tollway where this incident occurred in April of 2016. Some of you may remember Obama was president. It just shows how long these cases can take to go all the way up, and it's still not actually ultimately resolved, which we'll talk about. But for those of you who don't know, Sam Houston was the governor of Texas, was opposed to seceding, got overruled by the legislature, so he resigned before that occurred. But anyway, Houston has a lot of highways, and this occurred on one of them, the Sam Houston Tollway. But as I like to say, there's two types of people: Texans and those who wish they were Texans. So, but anyway, this is really a case that is kind of a classic one for the Supreme Court to take, because there was a circuit split on this question of whether excessive use of force cases under the Fourth Amendment, such as this, should be analyzed under a moment of threat doctrine that just looks at the literally could be a few seconds, as it was the case here, before the officer's use of deadly force in this instance, or a totality of circumstances test. And so the totality of circumstances was applied by the Sixth Circuit and Seventh Circuit in cases leading up to this, whereas the moment of threat test that just looks at that short interval was applied not just by the Fifth Circuit, but in cases from the Second, Fourth, and Eighth Circuits. So it made sense that the Supreme Court wanted to resolve that. What was kind of interesting was none of the judges in the Fifth Circuit opinion were enthusiastic about the test. They stated in a few different places they were duty-bound to apply it because it was precedent on the Fifth Circuit, and of course they can only overrule that en banc. And the plaintiff in this case chose not to do an en banc appeal. And of course, there was the concurrence by Judge Higginbotham, where he was explicit in saying he disagreed with the moment of threat test and was hopeful the Supreme Court would overrule it. But even the other two judges were not enthusiastic about it, if you kind of read between the lines. So, what we're really talking about here is, let me just kind of go through some facts of what occurred here back in April of 2016. But the individual who was pulled over, Ashton Barnes, who ultimately passed away there, this case was filed by his mother, Janice Barnes, as a 1983 suit against Officer Roberto Felix. And there's the municipal part of it, but that was basically set aside by the court because you can't, first you have to establish a valid case against the officer before you even get to that. So the district court applied the Fifth Circuit's moment of threat doctrine and dismissed the case. And then, of course, Janice Barnes appealed to the Fifth Circuit, which upheld that. And then we had this unanimous Supreme Court decision, instead saying that the totality of circumstances should apply, and remanded it for further proceedings based on that. There's a concurrence by Judge Kavanaugh that we'll get into as well. But let me get back to the facts here, because I think, that's, to me, in some ways, the most interesting part. But Constable Officer Felix pulled over Ashton Barnes, a young black man, for unpaid toll violations, which totaled all of $6.45. He was driving a Toyota Corolla, which his girlfriend had rented. And actually, the toll violations were from a previous customer. But, obviously, I'm sure the officer didn't know that. But I think it's fair to say it's not the most minor kind of case you can imagine. And indeed, in many states, toll violations are entirely civil, so someone couldn't be pulled over for it. And I think, obviously, people probably know a perspective from where I come at this. And so I question the wisdom of this type of policing. Although I very much, like Justice Kavanaugh, believe that traffic stops, particularly for dangerous driving and so forth, are a very critical part of the public safety role that police officers play. So I think there were certainly legitimate concerns raised in there about different contexts than this case, of course, many of which do involve, more, dangerous driving, things where there's a real issue there. And then also many of the cases also can involve where there's active resistance to arrest, which there really wasn't here. Now, obviously, we'll get into in just a minute some of what did occur. And I think, certainly, people can take different perspectives on that. But one of the interesting things about this is, and this is really something that I'm quite familiar with because of the unique setup here in Harris County, which includes Houston, but also various smaller cities and unincorporated areas. It's, one of the top 5 largest counties in the country. But we have these constable officers, and there's 5 constable precincts. They're each independently elected. I think it's fair to say they don't have as well established governing policies as the Houston Police Department. So, for example, HPD, along with Cincinnati Police Department, adopted what I think is a really nuanced and good policy, which I wrote a piece on in Governing about a year ago, dealing with high-speed chases, which is another direction this could have gone in had things worked out differently. But essentially, they rejected, there's a few liberal jurisdictions that said we're never going to do high-speed chases. And then, of course, you have a lot of departments that have no policy at all. But instead, what they said is we're going to, first of all, set a threshold of what does this involve to begin with. But then secondly, we're going to look at what are the circumstances at the time, including the risk to the officer, what risk a high-speed chase would pose to other drivers and so forth, and make sure we're kind of conducting that inquiry on an ongoing basis because the situation can change. But anyway, the constable's office has unlike HPD, has no policy, for example, on high-speed chases. Now, the other interesting thing that, that didn't get brought out, that's, I think, a notable fact is this occurred on a toll road. And again, it's regarding $6.45 in unpaid tolls, not from Barnes himself, as it turned out. But the Harris County Toll Road Authority, which is a very large operation, but they pay for the salaries and benefits of deputies who are assigned to patrol there, like the one in this case. Not only that, portion of the distributed use as they see fit. And so I think it does raise real questions about the incentives here and whether for any other unpaid fines, there would really be this level of interest in pulling somebody over. Now let's just, with that context, look at what exactly happened here. And there's a video which I can share that's from YouTube where you can see from the officer's camera what occurred. But basically, Officer Felix pulled over Barnes. Barnes did get to the shoulder, as everybody should. The officer approached Barnes's driver's side window, asked for his driver's license and proof of insurance. Barnes replied that he didn't have to pay and that the car had been rented a week earlier in his girlfriend's name, which was true. Barnes was digging around in the car. Officer Felix told him to stop. Officer Felix claimed to smell marijuana. Turned out the subsequent search did not find that. Officer Felix asked Barnes if he had anything illegal in his car, at which point Barnes turned off the vehicle, placed the keys near the gear shift. Barnes told Officer Felix that he might have the requested documentation in the trunk of the car. And so and then now we're on the dash camera and we're seeing Officer Felix ordered Barnes to open the trunk, which he did. Officer Felix then asked Barnes to get out of the car, and Barnes appears to open the driver's side door at that point, and is restarting the car. And at that point, Officer Felix kind of reaches in to the driver's area. Again, the door is just open, and Officer Felix draws his gun, points it at Barnes, and says, "Don't fucking move." And then the car does begin moving. And Officer Felix, at that point, steps onto the door sill of the car with his weapon drawn, and his head is above the top of the door, so he can't see in at that time. And he shoves his gun into Barnes's head, pushing his head hard to the right, and fires 2 shots that ultimately killed Barnes. Now, once he's on the door frame in the video, the car is certainly moving, or it starts moving as he gets on the door frame. It's literally like a millisecond. Now, one thing that didn't get covered in a lot of the reports, but was in the local news here back in 2017, there was a grand jury indictment, but it was that was no billed. And one of the other things I want to note is all the different groups that were involved. I don't have time to list them all in terms of parties and amici, but I think it's interesting. You had a lot of police reform groups, mostly left-leaning, that filed amicus briefs for Barnes, but also the Rutherford Institute, for example, which is conservative or libertarian. You had close to a dozen attorney generals, all conservative Republicans, who filed a brief and asked for time and did receive time at oral argument, arguing on behalf of Felix. You had various police associations, Los Angeles, California police chiefs, others that filed amicus briefs on behalf of Felix. But the Attorney General's one was led by our Attorney General here in Texas, Ken Paxton. Harris County, interestingly, declined to participate in the Supreme Court proceedings. They filed a notice saying they felt that their interests were already represented. I think, certainly Harris County is, the county attorney is a Democrat, and obviously probably takes a little bit of a different perspective on this than the attorney generals I referenced. So let's go back to the legal landscape here. And really the backdrop is United States, the court decision, U.S. Supreme Court decision 1989 in Graham versus Connor, again, setting forth the objective reasonableness for evaluating police use of force. And then in that, we're making sure to, and this is independent of whether you're using the moment of time or the totality of circumstances, but you're focusing only on what the officer knew at the time the force was used, and you're evaluating it from a reasonable officer standpoint. So that's all kind of baked in and isn't in dispute. And one of the interesting things in the unanimous decision is that the court emphasizes that it could cut either way as far as benefiting the officer or the plaintiff when you consider the totality of circumstances. So they point to a case, Plumhoff versus Rickard from 2014, a Supreme Court case, where there the excessive force of claim dealt with the fatal shooting of a driver at the end of a dangerous chase, which lasted more than 5 minutes. And there the totality of circumstances actually benefited the officer because there was really the defendant, the suspect and plaintiff was swerving around and doing all sorts of things to resist in the early part of the interaction. So I thought that was an interesting point. Now, looking at the concurrence that Kavanaugh filed, which is joined by Amy Barrett and basically all of the center justices except Roberts and Gorsuch. There's not a lot of legal argument in there. There really isn't any, but there's a lot of kind of statements and cites to research about the dangers officers face, which are very real, and kind of goes through some hypotheticals about what an officer, what their options are in a situation like this, and also just kind of the fact that when you make a traffic stop as an officer, now there's things on their computer sometimes that can give them a sense, okay, does this guy have an outstanding warrant for something really serious? But by and large, they're, when they walk up to somebody, they don't know who they're encountering, and what they might do and whether they have a weapon and all of that. And then, of course, it deals with a lot of the questions regarding whether to pursue somebody, whether to call for backup, gets into some interesting points about technologies that are emerging that might help the situation. So, for example, there's a GPS tracker now that's launched from a police cruiser, attaches to the subject's car, and tracks that. And so that could help obviate some of these situations in the future. But for whatever reason, Officer Felix didn't choose the option of just letting him go. He didn't choose the option of calling for backup or for whatever. I don't know what kind of technological things were available to him, but obviously he he had almost no time to decide, right? I mean, but he jumped on the door, so maybe it was an instinctive choice, but obviously it aggravated the situation, I think is fair to say. I think that the argument that you see because I want to make sure we, as much as possible, acknowledge the fact that there's competing interests on both sides of this as a general matter. I think from my standpoint, the facts of this case are really disturbing, and I think that frankly it never should have happened if you had the right incentives for the kind of policing and focusing on preventing and solving serious crimes. But anyway, putting that aside, I think there's real legitimate concerns about this. Kind of falls in the broader category of, are police going to pull back because of these types of potential costs of this type of litigation and so forth. And so I think that was raised in a lot of the amicus briefs from police groups. And I think it's important to point out that, obviously, not only do you have qualified immunity, but you have indemnification, you have insurance that many officers have. So the research has shown it's extremely rare that officers ever have to pay out of their own pocket. But that doesn't fully address the argument, right? Because you can argue that if the more in judgments that police agencies have to pay out, that you're going to get political pressure in those jurisdictions from city councils and others for police to pull back. And so, for example, New York City in 2024 paid out $205.6 million in police settlements. And Chicago's got a really high number too. And, if you read some of the scholarly research on qualified immunity, Joanna Schwartz, who I'm a big fan of, she makes the point that it's kind of a polarized system because you get a small number of cases that actually make it through this gauntlet of qualified immunity. And we'll talk about where this case will land on that in a few minutes. But those cases, you can get a huge payout. And so those people get a lot of money. And that's why you see those totals. And then the majority of cases, even many which I would say are probably have real injuries, end up taking nothing. And of course, you could have situations not just where somebody dies like this, but also ones where somebody's paralyzed and can't work and was supporting children and they get nothing. And so I think it's you can imagine different ways of dealing with this, even things like administrative compensation fund, where at least would cover somebody's medical care. And I mean, I think it's interesting to think about that in the sense that we are a decade from this case, and now I'm sure there's been obviously, I mean, the families obviously got nothing, and they probably will get nothing because now we'll talk about the qualified immunity aspect of this. When this case is remanded, I think the most likely outcome from my perspective, and others may have opinions, but it seems like they'll probably prevail once the totality of circumstances test is applied on the excessive force question, but it'd be very difficult for them to prevail on the qualified immunity question that will come up next, because how can you say that it was clearly established that this was a violation when in fact the Fifth Circuit, under the controlling precedent at the time in this jurisdiction of Houston, was that this was an excessive force. So that's, I think, where we're likely headed, that, the family is probably going to not get anything out of this, but they certainly got a unanimous Supreme Court decision. Now, I'll just conclude in talking a little bit about the qualified immunity issue. if anything, the burden is on the plaintiff to identify a case that's on all fours with their own factual pattern. And of course, it's really difficult because a lot of the cases either never get brought or they're never result in an appellate published opinion. So it's a Herculean task to be able to do that. And I think that we still need more research on the impact of reforms in terms of qualified immunity. As some of you know, Colorado made a major change right after the murder of George Floyd in 2020. They essentially got rid of qualified immunity. They capped what an officer, him or herself, could have to pay, which is 20 or 25,000, and that could be covered by insurance potentially as well. And there's one study that basically looked at crime rates in several cities in Colorado and didn't find any conclusive effect from that. But there's also some reports that it may have had some effect on, based on a survey of officers in Colorado, on police morale, their own perception about whether they were kind of the community backed them up. And it's difficult to untangle the issue of staffing levels, because that was during a time, I mean, it's still a big problem, recruitment and retention in police agencies, but it was particularly a problem in the few years following the passage of this bill in Colorado. It was a problem all over the country. So it's hard to untangle the effect there, whether it was worse than elsewhere, and what the counterfactual would have been had they not passed it. But certainly there's arguments on both sides that certainly, at least in terms of perception, there might be some officers who believe that a jurisdiction is less supportive of them if they don't have qualified immunity. But again, in terms of personal payouts, it's extremely, extremely rare either way. So I think that, as we move forward, I think my biggest hope would be that that jurisdictions actually consider how to maximize the chance of, or I put it this way, how to minimize the opportunities for this type of incident to happen to begin with. And that's where we do come back to, there's a really, I mean, the world would be a better place if Mr. Barnes was never pulled over for $6 in unpaid tolls, and that weren't his to begin with. And I think it ended up obviously putting the officer in a decision, a situation where he made a split-second decision that I think was not a good decision. Now he's still working, incidentally, for Harris County Constable Precinct 5. And I'm sure people will have a variety of opinions on that in terms of whether he should have faced any discipline. I guess ultimately the legal process, I think, in terms of the Fifth Circuit doing what they did, and the Supreme Court doing what they did, that worked really well, right? But the process of us taking a look at this case from a more policy perspective of what we should do going forward, what are the implications for what police should be focused on, officer accountability. I think we have a ways to go there. And of course, we also need to look at training and officer wellness and make sure we're putting officers in the best position to be successful. So with that, I'll turn it back over and hope we can have some questions and input from the audience.
Well, thank you so much for that summary of a lot of the associated facts with the case, as well as the conversations it implicates, and then the decision that we got. I will issue a reminder to our audience that if you have questions, you are welcome to submit those via the question and answer feature that's likely found at the bottom of your Zoom screen. And as those come in, I'll take host prerogative and kick it off with a couple of my own. Typically, in one of these discussions, I would start by asking particular questions prompted by the decision, if there were pieces of argumentation that weren't clear to me or whatever else. But in this case, we have a pretty straightforward opinion and concurrence. It's 9-0, it's fairly short. We get an answer. They're very clear about what they say and what they're not saying. So I'll actually start with the concurrence rather than the majority opinion, which to a listener who had oral argument and all the various conversations there and who has just read the majority opinion, it's a little bit different to read the concurrence than it is to read the majority opinion. So I'd love to start with what's your take on the concurrence? Why was it included? And what does it mean for this case in its next phase of litigation as it goes back to be considered under a totality of circumstances framework?
Yeah, no, it's a good question. I think um, to me, the most notable thing about the concurrence was that it didn't really, a lot of times concurrences will try to put a different gloss on the legal standard or legal arguments in the majority or opinion and say, well, what we think this really means is that, and maybe all 9 justices weren't willing to say that. But it really doesn't do that at all. I mean, I think it seems like it's really aimed at making sure that there's not people don't come away from this thinking that the Supreme Court doesn't value the job that police officers do. And I think there's like there's a sense in which obviously I clerked on the Fifth Circuit. I know how serene and quiet sitting in an office drafting legal research and helping the judge draft opinions. It's a very monastic existence in many ways. And it's very much in contrast with what officers face when they're out in the street. And I think the court, particularly the justice on the concurrence, are very sensitive to kind of not looking like this is a pointy-headed hindsight Monday morning quarterback. We're going to roll everything back and say, and somehow kind of construct a artifice of some officer who has no emotion or none of the kind of none of the all of us are impulsive, right, to a certain degree. All of us, so humans aren't purely rational creatures, right? So they're I think trying to make sure that that everyone who sees the opinion, including officers and associations represent them, have a sense that the court appreciates the situations that they're in. And so, but I don't think it changes anything in terms of the legal test. So yeah, that's kind of how I viewed it.
Got it. Thanks so much. We have an audience question, which I'll read out now. The officer in this particular case has to continue litigating, but could one say that on the whole, this case provides officers with a more robust mechanism for claiming immunity due to prior interactions with suspect or other relevant context?
Yeah, absolutely. I mean, if particularly if the suspect was obstinate, obviously any type of physical, moving towards the off. Also, it exhibits, like drunkenness or other signs of being unstable earlier in the encounter. I think that that in many of these other scenarios, the totality of circumstances approach can benefit, could work in favor of the officer. So I think that is an important context. I mean, the court did say, of course, in some instances, something that happens so close to the actual shooting can be by far more probative than what happened. I mean, it could be, depending on how long it was, 30 minutes or an hour early. The other thing that I should have mentioned earlier that I didn't is the court did not reach the question of what impact legally does it have if the fact finder determines that the officer created the situation that they're using to justify the use of deadly force. And I mean, I think that's actually kind of what strikes the average person about this is that, again, jumping on the door sill, it really escalated the situation, as did moving towards Barnes, it kind of into his space once the door opened. And that all happened so quickly. So that is something that seems like still is a loose thread out there because, it's one thing to say it's the totality of circumstances. And again, that can potentially benefit the officer in some cases, but it's another thing to say when, if in fact you believe that the officer escalated the situation, what does that mean in terms of their ability to defend an excessive force claim. And I think courts have been clear that even if an officer makes a mistake, pulled over somebody by mistake, that doesn't mean they cannot defend themselves. So I think that much is clear, but I can certainly see courts being taking the view that that it does certainly undermine the officer's case if they contributed to the danger.
Got it. I actually did have a question following up on officer created threat doctrine. Obviously, the court was very clear they were not addressing that in this case, in part because it hadn't been decided at the lower level and they weren't going to be a court of first review. Is that something, now that the case is been remanded, to be reconsidered under the totality of circumstances doctrine, that the Fifth Circuit has to consider in this case? Or, like the other circuits that have already been applying a totality of circumstances view, could that continue to remain a theory that doesn't necessarily determine or isn't resolved in this case?
Well, first of all, I do think ostensibly this will go back all the way to the district court to begin with. And of course,
sorry, yes.
presumably, oh yeah, no problem. And presumably there's a chance this could settle, which would probably be, particularly because Harris County, I stated at the beginning, and of course now there's a different leadership than there was even at this time. There's a different district attorney, different county judge, some commissioners are different. So, the people who would be, in charge of, appropriations to pay out a settlement or something, it's not even the same people that when this case started. So I could certainly see that happening. I mean, the likelihood, again, as I said earlier, is if this doesn't settle, it seems to me under the qualified immunity standard, the family's likely to get nothing. So I could see kind of a modest settlement, being attractive to both sides for different reasons. But but again, assuming this does get further litigated, I think that that probably I think the totality of circumstances almost has to include whether the officer contributed to the danger, because that is part of the totality of circumstances. But obviously, in a lot of cases, you'll have situations where the officer didn't contribute in any way, and it's just a question of they still might have not de-escalated, or there were off ramps that they could have chosen, but they didn't. So I mean, it does seem to me here, it's, especially if you watch the video, and I can put it in the chat, it's difficult to conclude that the officer didn't exacerbate the situation.
Fair enough. Leaving aside some of the particular facts of this case and backing up to some broader questions, were there, as this is an opinion that affects the entire country, were there any arguments or questions that remained that you were surprised to see left after we got this decision? And I'll ask the reverse. Was there anything that you're surprised not to see show up?
No, qualified immunity, obviously it wasn't really on the table. Yeah, I guess the other interesting thing was the federal government's position didn't change throughout the case. It seems that obviously the oral argument, I believe, occurred obviously after President Trump had taken over, but I think not much after that. I have to check on that. But I obviously there's been, just in the days of Department of Justice has basically gotten out of the consent decree business. And so there is this pretty big gap in how the current administration versus the former administration is approaching policing issues writ large. And it does seem when you have that juxtaposed with this unanimous decision. And so, I think that this is kind of interesting from the standpoint of, certainly on the right, there is this element of kind of sometimes we see the phrase in Texas, "Don't tread on me," that, yeah, we support law enforcement and all of that, but, here, this, guy's driving down the road himself and, isn't committing any violation at the time. He's not speeding. He was pulled over for this, $6 in tolls. So I think, the reaction to the ideological divide that, it's not so simple as, okay, we want to just support police no matter what, or we want to say police shouldn't enforce traffic laws, because of course they should. And it seems like that there's elements of this case that kind of connect with concerns that people have both on the right and the left about liberty and about, what the role of government is.
Okay. It was January 22nd. So we were 2 days into our new administration when this was argued. Yeah, of course. With that, I don't have any more questions other than what would be the final set of thoughts you have. So barring any from our audience, we may get to adjourn earlier. But final thoughts, statements, what should we be looking at as this case has been decided, other than how our court's going to be, particularly the circuits that have been using moment of threat and now have to transition, how they handle that, what's still outstanding?
Yeah, and I mean, I think, if you look at it from a research to do a study, you could have looked at the outcomes. Did they affect, attitudes of police about, their jobs and, certainly police hiring and retention, morale, and try to compare it under this doctrine versus the other doctrine in each of the states that are in the different circuits. I doubt you would find there's so many intervening factors that probably have a much greater impact on police staffing and morale. It would be really surprising if this difference in doctrine, which probably has even less impact than qualified immunity, would find that. But certainly the briefs that came from some of the police associations were, they warned the court that, from their standpoint, that this would undermine, police in terms of their authority and their willingness to take some risk in enforcing laws. And obviously, I think the flip side of that is, as we'd already talked about, the totality of circumstances can work in favor of the officer. So, and it was pointed out that even earlier in the case, Felix's attorneys weren't in their briefing arguing entirely against considering things outside of the few second interval, which is what the Fifth Circuit opinion focused on. So I think we have a tendency perhaps to exaggerate the real world implications of some of these interesting disputes in legal doctrine, and there's a whole lot of other factors that probably have a bigger impact on police staffing, performance, and morale, and so forth. But it's difficult to study because, as I said, you could theoretically do that kind of study, but nobody's done it, and it would probably be very difficult to do. So, we don't know for sure one way or the other. And I think when we don't know entirely for sure, people understandably tend to bring their own ideological and kind of professional lens to it. And it's not surprising, obviously, that police groups would want to back up, an officer. But I think, my biggest takeaway is we have to consider what are the long-term, not just in a vacuum, this case, but I mean, what is the long-term effect of police legitimacy, on people's trust in police for pulling people over and having this type of tragedy stem from something like this. There was a lot of coverage in Houston and a lot of events, particularly in the Black community and Black churches and surrounding after this happened. There was a GoFundMe. There was a lot of consternation, and certainly the family feels understandably very aggrieved. So I think that we have to look at these things in an iterative context and beyond just the particular aspect of the particular case, but how does taking this approach affect broader goals of building trust in police? And so I think that's my biggest takeaway.
Got it. Well, then last question on the effects of this case from an audience member would be, under the new standard, now that we have a totality of circumstances, do you have a sense of how the same facts will be considered at the lower court and how it will shake out? I know you've talked about, okay, if we get to the immunity side of things, that doesn't seem like it will shake out well. But if it's continuing to be litigated, do you have a sense of how the new standard will work out in this case?
Yeah, I mean, I think the expectation is that Barnes's family will prevail on that point. And I think, it's, I mean, the fact that there wasn't really any aggression towards the officer. Now, he could have, Barnes could have handled it better in a couple ways, but, it's hard to say that, the officer's life, I mean, you really can't say the officer's life was threatened until he decided to jump on the door. So, and so, yeah, I think that's how it will likely shake out. And then though on the qualified immunity, it seems like a huge mountain that Barnes is facing, given the controlling precedent of the Fifth Circuit at the time and the requirement to be clearly established and have a case on all fours. And there was another case in the Fifth Circuit from Arlington, Texas, back in 2014, I believe, that is almost exactly like this, and they ruled the same way. And they also said they got to the qualified immunity issue and said there's qualified immunity. So it's really tough when the all fours case, you need one in your favor, and there's actually one that's virtually the same on the other side. Yeah, I think that probably the best outcome for the family might be, a modest settlement if they're able to obtain that. But, obviously a unanimous Supreme Court decision will always be in the name of Ashley and Barnes. It's that doesn't happen all the time. So.
Well, thank you. I really appreciate you giving your perspective, especially as someone who's lived in the area, and summing up the case as well as the facts and where we may be going. We can wrap it there, give everyone back a section of their afternoons. Thanks also to our audience for joining and participating. We welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming episodes. With that, thank you all for joining us today. We are adjourned.